Are crafters and creators allowed to take book covers and use them to create miniature books, water bottles, notebooks, blankets, things like that? Let's talk to everyone's favorite IP and entertainment lawyer Tony to find out more.
My name is Tony Iliakostas. I'm an adjunct professor of entertainment law and IP at New York Law School, and I have an Instagram, YouTube, and TikTok account called The IP Professor that's dedicated to all things intellectual property.
Tony, we're seeing a lot of businesses pop up where creators are taking book covers and using them to make products from those book covers. Specifically, we're looking at like tiny books, books that can be used as jewelry, books that can be used in like dollhouses and displays. So are creators, just people who are making things, can they take people's book covers and make them tiny or make them big or do things with them and sell products?
No, ma'am, absolutely not. That's not going to happen. So let's talk about why. The cover itself, well, first, let's put the book aside, or let's talk about it all together, right? The book itself is a copyright, very much protected under copyright law. Every book has pages with information. That's why publishers will typically take the entirety of the book and they'll register it in the U.S. Copyright Office. But secondary to that, the book cover itself is also its own copyright. And oftentimes, any book cover may feature artwork, it may feature a photo, and those itself are inherently protected under copyright law. Take, for example, the Harry Potter books, or take, for example, Dr. Seuss books. Those are animated in some format on the book cover on the front by the publisher or maybe by a third party. But either way, that artwork is easily as protectable as the book itself. If you're in the business of taking that book cover and you're repurposing it by way of making little earrings, or you're making some type of like cutesy little water bottle or just anything of that sort, please beware, because what you're doing is you're violating a lot of things. First, you're abusing the first sale doctrine. First sale doctrine, if we're talking about like, let's say repurposing book covers into like placemats or water bottles, like we've seen a lot of people do, that's a total abuse of the first sale doctrine. And there are people that there is this rule in the Copyright Act with the first sale doctrine, where basically if you own the physical good, or rather, if let's say you created something that has an IP interest, like let's say a sneaker. A sneaker is protected by design patents. It could be protected by trademarks as well, because the trade dress of the sneaker may be registered in the U.S. Patent and Trademark Office. Certainly the trademarks with, let's say, any identifiable logos like the Nike swoosh logo or Adidas logo, those obviously are protected under those aspects of different branches of IP law. If Nike sells a shoe to person X, at that point, they have done their part and sold the good, and that's it. But now person X could sell it to person Y, and person Y is in the business of, let's say, modifying at mass scale all these different sneakers that feature other people's trademarks. Like, let's say they modify Nike sneakers to match like the uniform template of superheroes like Captain America, Iron Man, and let's say they slap a nice big Marvel logo next to the Nike sneaker. That's when it becomes a little bit more problematic, because now you're potentially creating consumer confusion. You're leading people to believe that these are Marvel sneakers. You're also leading people to believe that these were created by Nike as well, when all the while they've been modded. If you're taking someone's book cover and you're repurposing it as a water bottle, what's not to lead someone to believe, oh, this is a water bottle from Scholastic. This is a water bottle from Random House, from Penguin. I'm sorry, that is what's going to invite that level of consumer confusion. And not to mention, you're using someone else's copyrighted work for commercial sale. That's a little bit on the less kosher side of things. But even if you were to shrink it down to, let's say, little earrings or like miniature sized books or anything of that sort, something making it fun, you can't even sit there and say that it's transformative fair use, because yes, you're transforming it into something smaller, but you're still using the entirety of the copyright to make the product possible. You're making like a microscopic version of a book. You're still using the entirety of the book, the cover at the very least. So all that to say, be wise. I can't stress it enough. These are the kinds of things that are classic ripe cases for infringement claims to come up, where publishers will go after you. They'll give you a cease and desist. They'll serve it to you, and you won't know what to do. You'll be freaking out. And listen, I think every solution, there is always a solution to every problem. It's just a matter of being open to those solutions. So if you're asked to cease and desist, please honor the request, cease and desist all use of their IP in some fashion. But obviously, if you feel like you have a dog in the fight, go to a lawyer, ask for their help. And even before you get that, God forbid you got that cease and desist, go to a lawyer to begin with. Say, hey, listen, I have a business idea to create, little earrings featuring the book covers. Is that okay? Can I even do that? I want to make poster versions of book covers. Can I do that? I want to make water bottles featuring book covers. Can I do that? Speaking to a lawyer is going to give you the best foot forward, at least understanding the copyright landscape, what you're going to be going against, and moreover, if what you're doing is the legal and ethical route to take. And if they tell you otherwise, that's what the whole point of a lawyer is, to protect you and to be your advocate. And advocacy comes in various forms. And that even comes with them being willing to say no to you if that's what's going to take to prevent you from having to pay up thousands, if not hundreds of thousands of dollars to all these different publishers that are out there constantly gunning for a claim to be, brought against someone and getting some type of money in exchange. And I'll leave you with this. I say it all the time in previous videos. I've said it before, but before you use someone else's IP, always ask yourself, how deep are my pockets? Because that's what's going to be the name of the game in a scenario like this.
And I can venture to guess your pockets are probably not deep enough to deal with some of these big publishers. So this is probably something you want to avoid unless you have spoken to your lawyer and you have gotten proper permissions to do so, to make sure that everybody's on the same page, as you don't get a publisher and or an author not happy with you, especially if you like that author, especially if you like that publishing house. Do not get on their bad side. It will not be a fun experience for you, I promise. If you have questions, go ahead and drop those down below. And as always, you can reach out to Tony on his social media. Tony, where can everybody find you?
You can find me on Instagram, YouTube, and TikTok at the IP Professor. You can check out my entertainment law podcast called End Scene, with new episodes dropping every Friday on Apple Podcasts, Spotify, or wherever you listen to podcasts.
Drop the questions down below. Tony's coming back for upcoming episodes, and every single day we are helping you navigate the world of publishing, from your writing to your publishing to your marketing, to make this your most profitable and most stress-free year ever. We'll see you in the upcoming episodes.